Judge, can you hear us in the courtroom?
I can, thank you, Jamie. Time is now 1 o'clock. We'll call the cases Rita Anderson et al. Petitioners versus Mineral County Attorney, DV 22-53, and Rita Anderson et al. Versus Mineral County Sheriff, DV 22-54. This is the time and place for a status conference. I will ask who wishes to go first. I know that the status report petitioners have filed a written status report, so I guess I'd defer to the Mineral County Attorney's Office for their update.
We actually filed a written status report update, Your Honor, as well an hour ago, but it just basically references Jordan Kilby's letter after she and I had a meeting the 11th of April regarding the things that we're in the middle of completing. We still do not have the post files, the entire set, but the other things are outgoing. We also determined at that point in time two things. That one, we did need to send individuals, not just OPD, notices of the actual written questions that were there regarding those. And secondly, we determined then that the citizenship issue was solved by the Homeland Security thing filled out by the deputies. And thirdly, we figured out subsequently that we have 4 deputies that are non-compliant regarding the question of a medical exam regarding mental health. And those are based on the documents that I have in the personnel files that we have. And so those, we said we send in camera to the court and send in camera to counsel for the petitioners. Then we received a copy of the order which you did today. And also received subsequently, or this morning early, a copy of the stipulation by what was a non-party attorney at that point in time, who is a party now. And so we, at that point in time, figured, well, if now the captions we changed the way you said on your hearing, which is Ryan Fokin's capacity as Mineral County Sheriff, it's fine with us to change the caption. And then the other captions would stay the same. But we had some other issues regarding the Funk proceeding itself in respect to compliance by the deputies for the mental health evals for what we have. And so we, in our update to you, or notice, asked that one, we receive all the records that were not provided to us, that were given to other parties, but we did not get them, but I don't think the court did either. I'm not sure if you have them or not. And secondly, we ask, although we requested a mediator to talk with the county attorneys, the commissioners, and the sheriff's office for over a month and no one's responded, including Mr. Lansadell, about doing that, Jordan did say the hiring question needs to be mediated too. We said, fine, bring it on. So please give us the mediation alternative. And then we also requested, until we have compliance completely with the writ, including the mental health evaluations, that the action not be dismissed in respect to the sheriff. And it's not only the sheriff, it should say Ryan Funk in his capacity as sheriff and the sheriff's office. So there's no looming thing hanging around out there. That's the only things we asked. In terms of the other information for both writs in Jordan's letter, some of them have gone out already. We don't have the post files yet. The updated information, if we get a chance to review that, may answer the questions we had about the mental health evals, if those were in there, done by someone else that we don't have, and those things. And then the OPD disclosures, we had to get the list of addresses of all of OPD's clients, and Jordan was right. That OPD does not have a good index of individual people. They just send it to their lawyers, didn't send it to the persons, but when they are done representing you, they pull out their down, they don't have any ongoing obligation, so we had to change how we did those, so that's what we're doing with those. That's kind of the update with where they are. The only other thing I ask is, because now Mr. Funk is a party, he is bound by Uniform District Court rules to do the settlement mediation question that we asked to do. So we request you vacate Friday's update hearing regarding the question of retribution and give us a week to come up with a settlement master or a mediator to sit down and give us a path forward that'll work for everyone. Because now the Uniform District Court rules, although Mr. Funk has not responded at all, the court rules, now that he's in as a party, required him to do that before proceeding further with any contested action. So we would request that, and the county will, through the county attorney's office, for the commissioners, do the intervention that you ordered in today's order. So we are in, so we can finish the mediation portion too, and finish compliance. I hope that answers any questions you may have.
Well, there is a bit of confusion. So Sheriff Funk is the representative of the Mineral County Sheriff's Office and would be, for lack of a better word, saddled with all the prior filings that have been made in that particular case, especially made by the county attorney's office, who only recently was essentially relieved of representational duties by the court's order filed earlier today with the recognition of Lesher Lansidell PC as the appropriate attorneys based upon what the court saw as a conflict of interest between the county attorney's office and the sheriff's office. And incidentally, a conflict of interest that the court doesn't want to see. I think those two offices ought to be working hand in glove with each other. And I agree that some sort of mediation is necessary. The court has even gone to considering appointing a retired district court judge and a retired chief of police to assist both offices in coming into compliance with the writ. What I'm hearing, at least there is some partial satisfaction with the sheriff's office, and there continues to be progress with regard to the county attorney's office. So I'm going to turn first to Ms. Kilby to discuss the issue of the county attorney's office, which is 22-53, and then I'll turn to Mr. Lesher to discuss DC 22-54. Ms. Kilby.
Thank you, Your Honor. So, Your Honor, my sole focus has been just the compliance with the writ. And I guess it's hard for me to discuss just 54 without discussing, or 53 without discussing 54. So if it's okay with the court, I might go back and forth.
They're interrelated.
So at our last hearing, what I heard the court say was that the court was not going to essentially weigh in about Mr. Lansidell and Leitcher's representation, as that was an issue between essentially the commissioners, Sheriff Funk, and the county attorney's office, and I know that since then that has become an issue that the court had to weigh in on, but just by way of explanation, the representations that were made to us, the petitioners, were that Mr. Leisure and Mr. Lansadell represented the sheriff, and therefore we took that at their word, and we have been working closely with the sheriff and Mr. Leisure, as Mr. Lansadell is out of town, to help the sheriff to come into compliance with the writ. And again, Your Honor, that was our sole goal, and so that was the reason that we did that, and we appreciate that the court issued that order today, but we have been working closely with them. What I did, as you can see from the status reports, is once I received the personnel files, I looked through all of the files and compared them to the statute to determine whether each deputy, and I didn't do the detention officers, was in compliance with the statutes. The one thing that I found to be deficient that was addressed very early on was the mental health evaluations were not done by a qualified professional. This was something that was done under Sheriff Toth when, if the court remembers, in August of last year, Deputy Kunzelman testified that he'd not had a mental health evaluation. Mr. Congdon and Mr. Toth testified. Mr. Congdon stated that the evaluations had since been done, and Sheriff Toth testified that they had been done. It wasn't until we received, I believe it might have been before the personnel files, the documents from the sheriff through counsel, that I recognized that they were not done by it's a physician or a mental health professional. They were done by, I believe, a nurse practitioner, and in order to comply with the statute, the nurse practitioner had to have a specialty in psychiatry. So what Mr. Congdon is referring to that he is unaware of is that once that became apparent, I communicated with Sheriff Funk and Mr. Lansadell at the time. He was still in town, I believe, and Sheriff Funk immediately fixed that problem and provided us with proof of the appropriate mental health evaluations. That, I agree, should be provided somehow to either HR or the county, just so that we're all on the same page. But again, that is not the petitioner's job in this case. We're just looking to see compliance with the writ. So at this point, Your Honor, based on my analysis of the personnel files, the sheriff's office, I can represent that all of the deputies working for the sheriff, as well as the undersheriff, are in compliance with the statutory requirements as set forth in the writ. The only outstanding issue that I see with respect to the sheriff is attorney's fees, and I think that because these cases are so intertwined, that the court has made it clear that we would address that at a later date. That's certainly fine with the petitioners, Your Honor. With respect to the county, Mr. Congdon is correct. We had a productive meeting. It is our, I think, collective position that because 4618-101 relieves OPD of representation of their clients in final judgment, that providing the Brady and Giglio information on closed cases to OPD is not going to be enough. Practically, I've tried to work through that with OPD, but unfortunately, the way their system is set up, they're not able to tell. They can't put in a sheriff's deputy's name and then pull up a case. And so it's not like they're able to immediately identify all of the people who are affected. I think they would have worked with us if that was the case, but the best way, in my opinion, and I believe Mr. Congdon agrees, to make sure that everyone is on notice, given the statute that relieves them of their representation, would be for the county to send all of that information to the individuals, as they're the ones that have access to those names. Either that, or we could work with OPD to get a list of those names, but I just know how overworked OPD is as well, and so that could cause some problems there. So I think it's best, and Mr. Congdon's agreed to do it, to send out that information to those individuals. it looks like Mr. Condon has identified, and I'm happy to help with that, the individuals who did not have the proper mental health evaluations. And we've talked about this before, that the defendants who, you know, the state would call these deputies as witnesses have a right to know that at the time that the deputies were involved in their cases, that they didn't meet all the statutory criteria, and then they can do whatever they need to do with that information. There are situations wherein it's my position that it would constitute giglio information because, for example, and we've talked about this several times, the difference between particularized suspicion for a stop and probable cause for a stop. So they've agreed to do that. We have number 3 on Exhibit A to that status report is I have requested proof of citizenship of all deputies. That has been satisfied. Let's see. The other thing, Judge, that I think will clear some things up, and it certainly cleared some things up for me, is that Mr. Condon made representations that were accurate, that the policies, the hiring policies had been amended. However, I wasn't able to figure out, based on, we did receive the policies, how that had happened and where that happened. And so there was a sheet of paper in the jacket to those policies that it wasn't apparent that that was the amendment. At the bottom of the sheet of paper, it did say that it had been accepted by the commissioners, but it's just like a Word document. There weren't any signatures on it, and I haven't been able to find the recordings of the meetings or the notes that say that the resolution was adopted. And so I think we've figured out the misunderstanding there, that there was an amendment to the policies. Mineral County doesn't want to reprint the entire manual and distribute it, and that makes sense because it's expensive, but it just wasn't clear that that resolution was signed and accepted. And so that is one of the things that Mr. Condon and I spoke about. I said I would try to find the minutes. I have not been able to find them, so I've requested those from him. I don't think that they're absolutely necessary, but I do think that's part of the breakdown in communication between the sheriff and the county. That the sheet of paper was adopted. I don't believe that the sheriff was privy to that information, and I don't know how he could be. So with respect to the hiring practices, I do agree, even though I'm not sure it's my place within the writ, that some sort of mediation would be helpful, just so that everyone in Mineral County is on the same page about what their hiring practices and policies are. The other thing, to go back to the sheriff, Your Honor, is they did agree that going forward they would use a third party to do their background checks, and I spoke with Mr. Condon about this, and I think it makes sense because he's been asking the court to issue subpoenas, and he's been the one kind of looking into this. A lot of smaller agencies, I think a lot of agencies use third parties for their background checks, and so it would save a lot of time, a lot of Mr. Condon's time, certainly, and the court's time, if we just have a third party to do that, and then they could set the criteria for those background checks. I think, you know, Your Honor, essentially, the sheriff is in compliance with the writ. All of their deputies are qualified to be deputies by statute. And then the county attorney, again, once we were able to sit down and kind of go through this, we're moving forward, and I think once we're able to get all those notices out and a couple of the other things, the post files and then the emails as well, then we're on the right track. I do object to vacating the hearing on Friday, Your Honor. Mr. Jasper has mostly handled that. I think some of the retaliation issues go to him, and we have witnesses lined up, and I think it's important, and certainly he thinks it's important for the court to hear that. And I think I've covered everything. I apologize if I haven't, but again, my focus is really compliance with the writ.
Okay. Thank you, Ms. Kilby. Mr. Lecture.
Good afternoon, Your Honor. Your Honor, speaking on behalf of Sheriff Funk, Sheriff Funk hired our law firm solely to assist in bringing his office compliant with the writ issued by this court last October. So that's been our sole goal here. And, we've worked very effectively with Jordan in order to identify which statutory requirements that the court mandated the sheriff's deputies all be in compliance with. We had documentation of, and which, were issues, for example, mental health evaluations, and then there were a variety of missing documents. We've been able to check those boxes pretty quickly. We haven't tried to resolve the issues, the inter-county issues between the sheriff's office and the county attorney, because initial communications made it clear that was not likely without some court decisions on certain things, which two of which have been resolved in the sense that the court has recognized that the sheriff's office is the respondent here, and that Mr. Funk, as the elected representative who occupies that office, is properly a party to these proceedings, and that we're in fact representing. That puts us a long way down the road toward getting past some of the kinds of roadblocks we're running into, trying to communicate with the county attorney's office. That's helpful. With regard to sort of resolving the rest of the issues, the sheriff certainly does not have any objection to mediation. That would probably be helpful here. That said, I think there are probably some things that the court is going to need to weigh in on and make decisions about in order to facilitate that process and actually, give it some hope of success to resolve things going forward, so that there's some harmony in operations between those two agencies that obviously have to work closely together. To that end, the sheriff would also object to canceling Friday hearing, because I think some of the issues that we're running into here are best addressed in that hearing. And I think that will help the court to better understand the circumstance and where the holdups are. And just as one example, with regard to the emergency motion that I filed on behalf of the sheriff around the hiring of Deputy Micah Allard, the objection that we can't get clear answers on, for example, in what sense hiring Mr. Allard would not comply with county policies and procedures. The sheriff did copies of those previously. We still don't see any manner in which that wouldn't comply. And then we're being told that it would violate the writ, but when we ask in what manner would it violate the writ, the response we get is that the county attorney's office can't make that determination because Mr. Jasper shredded the relevant records, which is frankly nonsensical. In the sense, Mr. Jaspers did not own the sole hard copy of any record that would be necessary to determine whether Mr. Allard complies. The point being, it appears that there's an act of the grind with Mr. Jasper, and that a lot of things are getting wrapped around the axle over that dispute, which appears more interpersonal than legal, as far as I can tell. So I think we'll be able to flesh out some of this at the hearing on Friday. As far as our communications with the petitioners, we were on the same page that the current crop of deputies is in compliance with the statutory requirements that the court imposed. As we noted in the stipulation, the sheriff's office, as far as its own internal policies and procedures, has adopted a policy requiring statutory requirements and has promulgated a checklist for all new hires so that the sheriff himself can ensure and go through the checklist, since it is his responsibility to ensure that those any new deputies meet those statutory requirements. So I believe we're in a good place. Obviously, if the court would like to see any documentation of any of that compliance or has any questions around it, we're happy to provide that. And for the inter-county disputes, we can address that at Friday's hearing, I believe.
Okay. I'll give you, Mr. Congdon, an opportunity to comment on the status reports provided by Ms. Kilby and Mr. Lesher.
My comments would only be this. One, Your Honor, I would like to see all the records provided by Mr. Funk to Mr. Lesher and Ms. Kilby and Mr. Jasper, because we have not seen those. And the records we have from the personnel files, which is where all the deputies' personnel records are supposed to be for the county policy, etc., we have nothing that shows compliance for all the deputies that we have. So if I have those records today, I can look at them, if they're all in compliance, and we solve the problem of are the deputies compliant, is the sheriff compliant or not, and if the proper mental health evaluations are not there, then they're not compliant. So that's item one. And number two, the issue that you brought up is quite good. If you have a retired district court judge and a chief of police who can sit down and facilitate this, that would be delightful. And in respect to why I think vacating Friday is the appropriate thing to do, I'm reminded of Rule 11 of Cowboy Ethics, which is a very simple rule, and that's where this one will go Friday, probably, if we don't vacate that. Never take anything out of your mouth so big you can't put it right back in and chew it up and swallow it. That's Rule 11 of Cowboy Ethics, and I live by it. The problem I see is that there's enough blood going over the bridge or enough water over the dam that a whole lot of stuff may get said Friday, which doesn't facilitate good solutions. So I think we're better off to figure out how to have time to review the records that were provided. I also indicated in our update that we provide in camera the documents we have that show they don't comply. They weren't done by a nurse practitioner, they were done by a PA, a physician's assistant. And that's the reason why they were not compliant, and all of them were marked PA, which meant it wasn't a licensed physician who did them, that was what the statute required. But we thought we could get those to the court, get those to Lance and Jordan, but now we will also provide a copy to the other law firms, since they should have a copy too, since they now have authority to do that for this court's protected order. So that would be our thoughts, and any dismissal that's done at some point in time should include the sheriff's office and the sheriff themselves as a representative of that. And if we go that route with it, that works when we're compliant, but our concern is we're not compliant, and there still is not a clear picture of compliance with the policies adopted by the commissioners. And I told Jordan I'll find the records we've got. I just have to go through, and our HR person's been out sick. He's got pneumonia today too, but he's in today, but he's really ill. So that's the records we have. Those would be my only responses at this point, Your Honor. We just look forward to trying to move forward in a more positive manner if we're compliant.
Thank you, Mr. Congdon. Well, the court is going to maintain the hearing scheduled for 9 a.m. and please choose to use that hearing will be up to the parties. I will tell you that I am still dismayed that there appears not to be one core file for every deputy that contains a cover sheet with all of the statutory requirements ticked off, as the case may be, and then all of that information found in the file. I don't take a position as to whether that file is maintained by the sheriff's office or maintained by human resources in the county. Again, that's a county matter, and I'm not going to weigh in on administrative details like that. Frankly, that seems to be the county commissioners, the HR office, the county sheriff, and the county attorneys who needs to work together. I'm happy to facilitate and appoint a mediator if you all can't agree on a mediator. I do believe it's critically important, as I said before. The sheriff's office, the county attorney's office ought to be working hand in glove on all matters related to investigation and prosecution. And that necessitates that they should be working very closely on the issue of the compliance with the writs, since the writs don't really provide anything new. It just simply reiterates what is statutorily required in the first place. And if those processes were not in place before, they need to be developed, because it seems to me that the county attorney should have input, not control, but input over the hiring of sheriff's deputies, because whatever that sheriff's deputy does, the county attorney's office will be saddled with in a prosecution. So certainly I think the county attorney's office needs input in the hiring, as does HR need input in hiring. But as indicated in my current order, it is the sheriff who hires and fires, consistent with statutory prescription, as well as reasonable county personnel regulations that the county commissioners have the right and duty to set. So again, I think what we're talking about as far as, gee, I haven't seen this, and gee, I haven't seen that, or yes, we are in compliance, there needs to be some information sharing among council, and I think the objective should be to assist the county, again, whoever is the holder of those files, they take no position, but to have one central file so that every deputy's information is in one place, and a person can very quickly and easily determine that all statutory and frankly county requirements have been met in the hiring of that deputy. I'm encouraged that we do seem to be making headway. I appreciate the stipulation regarding the sheriff's compliance with the writ. I'll still allow the Mineral County Attorney's Office to weigh in after they have received all of the information. Again, it's the County Attorney's Office who will be saddled with any non-compliance, because that is Brady and Giglio information that then the County Attorney's Office will need to disclose. The court is not going to dismiss the matter involving the Mineral County Sheriff, Sheriff Funk, 22-54. I think there are issues that still need to be resolved. I don't know that the court is inclined to weigh in on all of them, but certainly council can raise them with the court if they wish. Again, I do want to see by our next status conference further progress on the notices that need to go to all defendants who were convicted and where they ought to have received Brady Giglio information. And again, I want to make sure that all information has been exchanged, especially in DV 22-53 regarding emails involving the former county attorney, and of course that post files have been received and acknowledged. Again, as far as the issue of Mr. Allard's hire, that is an issue for the sheriff's office principally, in consultation with the county commissioners and their policies, as well as the county attorney's office. So I am going to leave it, and I'm going to force you all to work together in a way that you should be working together anyway. I'll take suggestions on when we should have our next status conference.
Your Honor, I think I defer to Mr. Condon with regard to timing because it's mostly his work that is subject to the compliance.
Probably sometime in late May, Your Honor, would work. But the 21st is this Friday, so if we were that last week in May, 21st, 23rd, 25th, somewhere in there, if that works for the court, that should allow us enough time to make significant progress. May we set this for 3 p.m. on
May 24th, that's a Wednesday.
That works for the petitioners, Your Honor.
That should work.
Okay. Mr. Lecter?
Works fine for us as well, Your Honor.
Court sets a status conference then for 3 p.m. on Wednesday, May 24th. My hope is by that time, we will have this matter wrapped up. Again, the retired district court judge I did speak with I had a different role in mind. I'm happy to ask if she would be willing to mediate issues involving the county attorney's office, county sheriff's office, and to the extent necessary, the Mineral County commissioners as well. Is that what I'm hearing?
That is from the state, from the county, that's our position, Your Honor.
And Your Honor, I'm sorry, did you mention who the retired district court judge is?
It would be Karen Townsend.
Your Honor, let me see Mr. Congdon proposed several potential individuals that might actually be better positioned for this particular mediation. For example, former Revelle County Attorney George Korn. I will get with Mr. Congdon and see if we can find an acceptable mediator. And if not, then we will take the court's suggestion.
I would have you determine that by Friday, and so I'll be inquiring again at 9 a.m. on Friday the 21st.
Will do, Your Honor.
Anything else that we need to address?
The documents from the sheriff's office, what's a reasonable time for me to receive those? I'd like them before Friday's hearing if we can get them before then.
Your Honor, they'll have them before the end of the day.
Okay. Thank you.
Okay. Well, thank you all. Again, we'll see you on Friday at 9 a.m. and then the status conference 3 p.m. on Wednesday, May 24th. The court is in recess until 2 o'clock.
Thank you, Judge.
Thank you.